Starting with the basics here is important. What happened with the Supreme Court ruling, and what are the mechanics of what it means for H-1B visas that we've just outlined?
So the Supreme Court ruled that federal district judges cannot issue nationwide injunctions. And so this decision basically affects how legal challenges to President Trump's birthright citizenship executive order can actually proceed. And it's scheduled to go back into effect July 27th. So what this means is that if an H-1B visa holder wants to insulate their baby from the effects of the executive order, they need to sue individually or join a class action lawsuit or live in a state that sues or successfully obtains an injunction. So essentially, the ruling opens the door to piecemeal enforcement of immigration policies, which will potentially lead to differing legal standards in different parts of the country. But coming back to your question about how it impacts tech companies, what this means is that there's a possibility that the babies of the employees of these tech companies will be treated differently depending on where the employee sues or where the employee lives. And that is going to create a whole new category of employee questions and policy considerations for the company that it has not had to grapple with in the past.
We heard from U.S. Attorney General Pam Bondi about this in Friday's show. Just listen to what she had to say.
So birthright citizenship will be decided in October in the next session. However, it indirectly impacts us because, as you correctly pointed out, if there's a birthright citizenship case in Oregon, it will only affect the plaintiff in Oregon, not the entire country. So yes, it's indirectly, but that's pending litigation, and we're waiting on that in the next term. We're very confident in the Supreme Court, but again, it's pending litigation, and that will directly be determined in October, but it indirectly impacts every case in this country, and we're thrilled with their decision today.
Hiba, would you kindly interpret and explain the pending action in October that the Attorney General Bondi was talking about?
So my understanding about what's happening in October is that there's going to be a decision in terms of like the merits of the birthright citizenship executive order itself. So if you recall, what happened on Friday was the Supreme Court only ruled as it pertains to the judge's ability to issue a nationwide injunction. There has not been any sort of a decision on the constitutionality of the birthright citizenship executive order itself. So therein lies, I think, the issue. Because we're facing the next several months of different states having different standards and babies born in those states being treated differently, that is where the logistical, administrative, and possibly even bureaucratic challenges will arise, both for the high-skilled H-1B visa holders or high-skilled immigrants in the country, as well as the companies that employ them.
Let's look at those companies. Again, Hiba, we've got a beautiful chart that shows how integral H-1B visas, for example, are for certain US tech giants. Amazon, there's Infosys, of course, that we all recognize is dependent on H-1B as well, Cognizant, Google. This sort of perception of instability in immigration, what does it mean for US employers, do you think?
I think it's important to note that the tech companies in the United States do rely on high-skilled immigrants from other countries. And part of the reason for their success and their ability to remain competitive on a global stage has been their ability to hire the best and the brightest. So if there are high-skilled immigrants out there who have even the slightest perception of instability in the U.S. immigration system, there's a chance that that might factor into their decision to accept an offer from a U.S. company or accept an offer from a company in another country. So what the companies and, folks in the United States really have to, I think, grapple with is whether they want those skills and that innovation to go elsewhere as opposed to the benefit of the U.S. companies.
Hiba, what are you advising in the here and now? You must be fielding countless calls. And if there is an employer who's trying to lure in someone who might eventually already be pregnant or thinking about it, are they going to have to sue on an individual basis, do you think?
So individuals, as it stands right now, until something changes, unless and until something changes, if an individual wants to insulate their future baby from being impacted by the birthright citizenship executive order, either they have to sue individually, or they have to join a class action, or they have to be in a state that sued, on the merits of birthright citizenship, so that the individuals from that state are somehow insulated from the applicability of the executive order. So that is where I find some challenges to tech companies that actually employ a lot of these visa holders, because what I think is going to happen is companies are going to start to get questions that they've never really had to answer before. For example, what if the employee is scheduled to relocate to a different state, but doesn't feel comfortable relocating to that state because they're concerned about whether or not their child will be considered a U.S. citizen upon birth? Is the company now going to change something about the relocation? Are they going to extend some sort of reasonable accommodation? Are they going to stay away from the topic altogether? These are now the company policy considerations that I think a lot of tech companies are going to have to decide.